You didn't say anything about provisional patent. Is there any reason why you didn't say anything about it?
Yes, we can definitely talk through that. That's actually another question that was raised before. I just wanted it to be very, basic. But we can talk through the provisional patent application process. It's the same first step where you create an application and you file it with the Patent and Trademark Office. However, it's not examined. It just gives you 1 year, right, until you have to do something else. So provisional patent application filing is really good if you're going to do some form of public disclosure, but you're not really ready to go through the entire examination process. You want to have that additional year of time. Also, while in the United States, if you do some sort of public disclosure, say today, you have 1 year from that date in which to file a patent application. In most countries, as soon as you do some form of public disclosure, that's it, right? It's absolute novelty, right? Standard. You're not going to be able to go forward and get a patent in those countries. So a provisional patent application is a good way to precede any sort of public disclosure. Okay? I saw another hand there.
Intellectual patent. I'm not talking about building a widget or producing a widget. I'm talking intellectual, writing code.
Yes. Like a business method patent?
Not business method. A lame representation. But the meshing or the networking behind all social networking sites, that type of intellectual code that's written.
Now
As in an app for a smartphone,
Right.
a website with an app,
right.
working in conjunction with each other, that type of intellectual code. So you're not producing a widget, you're
Right.
actually producing to lock in or secure code and or the business plan
Right.
that produces whatever you're trying to do.
Okay. So intellectual patent, and you were talking about the code and the business, the actual code, protecting the code, as well as what it does, right? So when we talk about patents, you can talk about products, you can talk about widgets, you can also talk about processes. And there was actually a case recently, it's called Bilski, which talked about how do we, say what is patentable subject matter, specifically regarding processes. A business method patent is a type of process, as well as the code and what the code does. You can definitely go through and claim code, right? You can definitely go in and claim what the code does. All of those things would be considered processes, okay? So you can go at it that way. It's still a utility patent as long as the process has some sort of utility in the end. It does something. Now, the case with the Supreme Court was kind of, do you have to have some sort of machine or transformation? And the Supreme Court said, no, you don't have to have that in order to have patentable subject matter. You just have to have a process. And the process has to do some sort of function. Okay? So
in the end, the process, well, here's
Right.
a better question. Does the process have to be patented with the code? Or can this process give you this result without, at first at least, defining exactly the code between these 5 steps to give me this result?
Okay, now that's an excellent question. Do you have to claim the code, right, in order to claim the process? You're not really that limited in that you have to put into the claim, I claim, and then list out every line of code in there. You can claim, I claim a process that ends in this result.
Okay.
Okay?
But you have to
But
demonstrate
yes,
the
you do.
art,
Right. That's the other part, though, is that in your patent application, there's a section before the claims that's called the specification, and in there you have to show not only that you have possession of this invention, but that also you can describe it in a way that enables someone else to do it. Okay?
Right.
And there's another standard in there where you have to show the best mode. So you have to show how you have knowledge of this information and how to show someone else how to do it. Typically, especially when you're talking about process of your type, you're going to need to include the code in the specification at least, because that's going to meet how you have possession of your invention, how you're enabling someone else of ordinary skill in the art to do your invention,
Do the same.
and then also it gives you the best mode of how you feel the best way it is to get your result.
Okay.
All of those things are in support of the claim, which has to state what is your process, what is the final result, what are you claiming, what is
Right.
patentable.
Okay.
Okay, does that make sense?
Yes, absolutely.